Hello, my name is Stephen Minnis and I'm joined today by Richard Meeran. Richard Meeran is a partner at Leigh, a public interest and human rights law firm here in London. Richard, welcome.
Thank you.
This practice area of human rights litigation, where actions are being brought against multinational companies for alleged actions that they've committed offshore, Leigh has pioneered this practice area here in the UK. Could I ask you how this practice area has come to develop here?
Well, it's an area we started in the early 1990s where we were looking to hold multinational corporations responsible legally for harm that was caused in developing countries by their operations in those countries. And so we embarked on this area in the early 1990s, and since then it has developed quite significantly, and certain hurdles which were quite significant at the outset have been crossed, and the future for this type of case is looking much more positive than it was all those years ago, although there are still many challenges.
And with these cases that are being brought against multinational companies, what kind of harms are being alleged?
There are various types of harm that are the subject of the cases, which are all tort cases. So they're all cases in which it is alleged that the British multinational company, whether it's a parent or other entity, owed a legal duty of care to the claimants in developing countries. So there are cases which are brought for people who suffer occupational injury and disease in the overseas operations of multinationals. For instance, the case that we did for South African asbestos miners, or the workers who had been poisoned by mercury. Those were cases against companies called Cape PLC, the asbestos case, and Thor Chemicals was the mercury poisoning case. Then there are environmental damage cases, and cases that people would have heard of that fall into that category are the cases against Shell for the victims of the Nigerian oil spillage, and that's a case which has just been settled very recently for $55 million. You may have heard of that one.
Yes.
And then there was a case a few years ago, another environmental case brought by 30,000 residents from Côte d'Ivoire against a company called Trafigura, and that case surrounded the export of toxic waste from Europe. And in addition to that, there are cases which I suppose you would call more conventional human rights cases. And an example of that category would be the case that we brought against Monterrico Metals, a case that was settled a couple of years ago. It involved a group of indigenous Peruvians who objected to the siting of a mine in a remote area of Peru near the border with Ecuador. And during a protest, an environmental protest, they were detained on the mine site by the Peruvian police, and many of them were tortured, and sexual abuse of women who were involved in the protest also occurred. So that's another type of case. So there are a variety of different types of cases that have been brought.
Yes. And in terms of the outcomes of these cases, they tend to settle before a final judgment. Is that the case?
In these types of cases, you'll appreciate there's a lot at stake for both sides. From the victim's perspective, they are invariably impoverished people who are desperate for compensation, and it's therefore in their interests if a settlement can be achieved at an earlier stage without having to go through a protracted trial and the risks of losing and of possibly not obtaining the kind of level of compensation that might be offered by way of settlement, then it's in the victim's interest to settle. On the company side, there's also equally a lot at stake. There's the risks of losing and all that would entail in terms of paying damages and costs and adverse media coverage and reputational damage. And therefore the benefit to the company of an early settlement is also clear. Now, I mean, this might be often much to the consternation of campaigning groups and sometimes the lawyers as well, because often we would, on a personal level, like to see a verdict being obtained against the company. However, you know, you have to look at the interests of the parties, and which must really be what decides the way in which a case progresses and whether it settles.
And in terms of the interests of the clients, where you have the clients maybe in South America, they may be in South Africa, the case is being litigated here in London, it must be a very difficult process for the clients to go through, often having suffered terribly beforehand.
I think this is, I would say this is a bewildering experience generally for clients. You've got people who have been injured or whose environment has been damaged. They may be involved in conflict over these issues. They live in remote areas. They're often illiterate and with very little education at all. They have no perception usually of the legal process even in their own countries, let alone in a country thousands of miles away and where the whole process is in a completely different language.
Yes.
It really is something totally alien, and that requires a lot of work and communication on the ground with clients through campaigning groups and trade unions and so on, to be able to ensure that the clients do have some kind of reasonable understanding of what is going on. And of course, you know, as part of the legal process, you have to gather evidence from the clients. They're often asked very detailed and complicated questions, which again is really quite bewildering for them.
And that actually leads us to another interesting aspect of this area of practice, which is that it's often necessary to collaborate with local lawyers, with NGOs, with unions. How have you found working in what are essentially transnational teams on these matters?
Well, it does pose a significant challenge, and it is absolutely vital when pursuing cases of this type that you understand the context in which you're operating, the interests of various stakeholders, not just the victims themselves, but other members of their community, provincial government, national government, trade unions, other local groups. You need to understand that context and the dynamics of the situation in order to be able to pursue these types of cases effectively.
Yes, and in terms of London having become a place where these matters can be worked through, how important has an engaged judiciary been in receiving these cases and in processing them?
I would say we've been very fortunate over the last 20 years in having a very progressive and open-minded judiciary, which has enabled the law to develop in key areas to the advantage of victims. And if I just give you an example of how things were 20 years ago compared with how they are now, I can remember when we did our very first case for a group of South African workers, that a question was asked as to why all these South Africans were suing in the English court. Well, nowadays no one would ask that question. The judges wouldn't bat an eyelid, because it has become quite normal practice for these types of claims to be brought in England. And so that I think is very positive.
And stepping back from any particular matter, I mean, obviously the client's interest is paramount, but Have you also seen an effect, a deterrent effect on other corporates, that they see these matters being worked through, they see their potential liability, they change their practices?
Well, we have no doubt of the deterrent effect of these types of cases, not just on the defendants in the cases themselves, but on other companies who will be aware of what the consequences are of not behaving responsibly in a developing country. And that, after all, is a key objective of tort litigation, to constitute a deterrent against bad practice, as well as compensating victims of bad practice. And it certainly has been an objective for us from the outset of bringing this type of litigation, primarily for the benefit of the people that we represent, but also with the wider goal of ensuring that companies are held to account legally, and that they are deterred from behaving in a way which violates the human rights of people in the companies and the countries in which they operate.
And just finally, we see a great deal of investment these days coming out of large emerging economies into developing countries, a great deal of corporate activity. Is it conceivable that this model of litigation could be used at some point to hold companies to account who may not be based in the UK or the United States, but perhaps in China, India or elsewhere?
Whether or not people are able to bring claims, for instance in China, against Chinese multinationals depends on the legal environment there, and whether in particular it is possible in practice for victims to gain access to justice in the Chinese courts, and what laws will be applied. Now, in developing countries, there have been significant obstacles to people gaining access to justice, not least the difficulty in getting lawyers to represent you. And that is why victims have looked to the courts in the US and the UK, for instance, where lawyers are willing to act because certain funding arrangements and procedures are available which enable that to happen to some degree. And I can't stress enough how fundamental this question of being able to obtain funding and legal representation is in being able to pursue these cases. It's as fundamental as having laws available which make the company liable. It's as fundamental as having a court that will accept jurisdiction. Because even if you have the ability to obtain jurisdiction and the laws available to hold a company to account legally, it doesn't mean anything unless you've got lawyers who are in a position to represent you in pursuing a case, especially in cases of this type of complexity, in which you will have on the other side a multinational corporation which is well resourced, for which money is no object, and which is able to afford the most expensive and numerous lawyers and experts.
Well, Richard Meeran, thank you for joining us.